Let me start by expressing my gratitude for allowing me to crave your indulgence in making this statement. Chairperson, during the testimony of Dr. Ben Ngubane, you asked a pertinent question, which, in my opinion, if answered, will put into context and clarify the events that took place at Eskom during my tenure there in 2015 and 2016.
Yes, just hang on, Mr. Molefe. I think you might wish to bring the mic a little closer to you so that you are loud enough, and you can keep your mic on throughout. You don't have to switch it off when I'm speaking or when he's speaking. You can just keep it on all the time. No, yes, you can continue. I just want everyone to hear what you say properly.
I don't want to cough into it and give the whole country corona.
Yes.
Chairperson, during that testimony, you referred to a question that needs to be put to Optimum Coal Mine along the lines of, and I quote what you said, how did you allow whoever signed on your behalf to sign a contract that the price would be the same for 10 years or more? Were they sleeping or what? Or what was? How could you have signed such a contract? Nobody signs such a contract, close quote. Those were your words, Chairperson. And unfortunately, Chairperson, these questions were not put to OCM. Because I think, although it was during Dr. Ngubane's evidence, you were asking about OCM's lack of, or the reason behind what they did. But the answers to these questions are at the heart of how and why we find ourselves where we are today. While they were not asked, nor had they directly answered these questions, Glencore did shed some light as to how they had put themselves in that precarious situation out of which they were demanding to be rescued by Eskom. Glencore did not sign the contract that you refer to. Glencore bought the contract with the company that had signed the contract. This is in the evidence of Mr. Efron before this commission, and it was on the 13th of January, it was on the 13th of January 2020 that he gave this evidence, that they had bought that company together with the CSA, Coal Supply Agreement. Although Mr. Efron is a chartered accountant, he admitted that Glencore did not conduct a due diligence on Optimum prior to the acquisition of the company and the contract. Nor had they bothered to acquaint themselves with how the coal supply agreement worked. This was in page 3 of his statement. In page 3 of his statement. Instead of conducting due diligence and understanding how the coal supply agreement worked, they did something extraordinary, Chairperson. They sold 9.64% of the shares in the newly acquired company to Mr. Cyril Ramaphosa, a political heavyweight, and made him chairman of the newly acquired company. That was a strategic decision to use the former Secretary General of the African National Congress and former Secretary General of the National Union of Mine Workers, a member of the National Executive Committee of the ANC at the time. They knew that the profitability of the company could only come from a successful renegotiation of the coal price and ignoring by Eskom of the penalties that were accumulating at the time. Mr. Ramaphosa was their bet. The profitability of Optimum was therefore dependent on the peddling of political influence and the extent to which Glencore would be able to exert pressure on Eskom directors and management, and not on the fundamentals of the company that they had acquired. This, in my opinion, was the source of Glencore's problems. They had made their bed and needed to lie on it. It was unfair and arrogant of them to demand, as they were doing, that Eskom should effectively pay for the irresponsible manner in which they had tied themselves into the proverbial knot. You observed, Chairperson, that on my arrival at Eskom, there was, and I quote you, a complete change of attitude on the part of Eskom on the deal that had been proposed and had been supported by various levels of management, close quote. You were referring to the deal that had been entered into by Eskom management and Glencore to save Glencore's skin from the consequences of purchasing a company having not conducted due diligence. Eskom management and Glencore were in the process of subverting Section 38 of the PFMA. Section 38, 1C, Roman figure 1, which talks about the duty of a state-owned entity or a state body to collect what is owed to it. On the 8th of December 2020, during the course of these hearings, the evidence leader, Advocate Selika, was at pains to explain how Glencore had fallen into hardship because the export price of coal had taken a nosedive. Dr. Ngubane tried to explain to the Commission that when the international coal price was high and Optimum enjoyed super profits, they had not shared their spoils with Eskom. What was unfortunately lost in that exchange is the fact that Optimum was a cost-plus mine. It had been built with Eskom's capital and had been given a 40-year contract. Eskom had responsibility for the mining costs, and in return, Optimum received a fixed margin. Eskom was, and then I think at some point during the hearings you referred to this as an absurd arrangement. Eskom was unfairly excluded in participating in the super profits of the time when times were good. And yet, it was expected to fork out more capital, forgo its legitimate price expectations, and subsidize rich international corporations when the times were bad. That is the situation that we found ourselves in. You correctly pointed out, Chairperson, that Eskom had a legitimate contract with Optimum. In terms of that contract, we at Eskom were supposed to get from them coal at the price of 150 rand per ton until 2018. Those were the terms of the contract. Whether they liked it, whether they didn't like it, those were the terms of the contract. In addition, they had accumulated penalties in terms of that contract to the value of 2 billion. Evidence was led in this commission that 2 billion was not a figment of my imagination. That 2 billion was calculated, had accumulated from 2012. I think it was Mr. Bester who said that he actually had calculated the 2 billion. And during his hearing on that matter, there was debate about whether or not it should have been 1 million more or 1 million less, but it was about 2 billion. Optimum demanded that the price of coal be increased to 530 rand per ton and that the penalties of 2 billion should be written off. Somebody mentioned 530 the other day, and Advocate Selega jumped and said it was not 530, it was 400 and something. But Advocate Selega, when they came to me for the first time, the figure was 530. It may or may not have been written, but that is what I clearly recall. And they later on reduced it to what you refer to. But the original demand, at least to me, it was 530 rand per ton from 150. It was their opening negotiating position. 530 rand from 150 rand. An increase from 150 rand to 530 rand per ton would have meant a transfer of 6 billion rand from Eskom to Glencore over a period of 3 years, 2015 to 2018. Add to this the 2 billion write-off of the penalties that they were asking for. The amount that Glencore wanted Eskom to pay for their original mistake of not doing due diligence was 8 billion rand. 8 billion rand, Chairperson. Your observation that there was a complete change of attitude on the part of Eskom on the deal that had been proposed and had been supported by various levels of management when I arrived at Eskom is absolutely correct. I'm not ashamed of this change of attitude that occurred. When I arrived, I was having Eskom's interests and those of the country at heart. What was happening was wrong on many fronts. It was literally going to financially ruin Eskom. But there was an added issue to this. The Glencore position would have seen an inequitable situation. The poor and most vulnerable in the country would subsidize the dealings of the rich. There was no way that I could, with a clean conscience, attend public gatherings and meetings and shout from the rooftops that Soweto residents needed to pay their debt to Eskom, when I was allowing international corporates to disadvantage Eskom on many fronts. Moreover, I could not face Eskom employees and unions and tell them that their bonuses will not be paid or that their salary increases will be zero. Their bonuses will not be paid, as was nearly the case in 2015. And that we had no funds to fix the apartheid wage gap that still exists between black and white employees of Eskom. There is still an apartheid wage gap at Eskom. While rich international corporations were unduly exploiting Eskom. As I have stated, the payments to Glencore would have sunk Eskom. You will recall, Chairperson, that this was at the time when load shedding was becoming the norm. I could not, Chairperson, say to South Africans that load shedding will continue because we do not have enough money to conduct planned backlog maintenance on our electricity generating fleet, and still allowed 8 billion to be unjustly transferred to Glencore. When I arrived at Eskom, a de facto board of the company had been established outside of the company in the form of a war room in the presidency. Management had to report to this war room. Ms. Mazietsi Mokolo was here yesterday, and she explained, Chairperson, to you how the war room demanded meetings with management and officials of the Department of Public Enterprises every Friday at 7 a.m. Every Friday, they had to present reports. So when I got there, the biggest activity that was happening at Eskom was preparing war room reports. From Wednesday, we must start preparing the reports, make sure that they are ready for Friday, 7 a.m. Then it's weekend. Then Monday, Tuesday, we work. And then Wednesday, we start preparing reports again. It was an untenable situation. There was a board, a de facto board, that was outside of the company. And what is even more strange, Chairperson, is that there has been evidence here, including by Ms. Mokolo, who was here yesterday, that members of the board, the legitimate board, the legal board of Eskom, were not seeing those war room reports. So, management was reporting to the war room. But it gets even better, Chairperson. The Deputy President of the Republic, Mr. Cyril Ramaphosa, was the chairperson of the war room. He was, in fact, the de facto chairperson of Eskom, the de facto chairperson of a de facto board that was outside the company. He was the de facto chairperson and had started playing this role directly from being chairperson of Optimum. When the deal was done in 2012 and he was sold shares, or he bought shares, he was made chairperson. 2014, he became deputy president and chairperson of the war room. One would have expected corporate governance requires that there must be a cooling off period, precisely for things like this. Here is a person who was engaged in saying we must renegotiate. That contract was signed in 2014, the contract that I found at Eskom. We must renegotiate effectively 8 billion rand. Moves and becomes the de facto chairperson of the company. In fact, he sold his shares to Pembani. I'm not sure if that was arm's length, but he sold his shares to Pembani. But at the time when I got to Eskom, and when he was deputy president, and he was chairing the war room, the deal had not gone through. It was awaiting Competition Commission approval. I think that was granted in August. So, I suspect there may have been conflicts. And then again, I'm not an expert. The membership of the war room included people like Professor Eberhard from UCT, who has never, in my presence, uttered an intelligent academic or sane word about electricity or corporate strategy. I quickly came to realize that the war room was not about load shedding and turning Eskom around. Something else was happening. Eskom senior managers were being distracted from fighting load shedding by being made to attend endless meetings at which they were supposed to give unending and meaningless reports. I was uncomfortable with the war room and stopped attending its meetings. If the war room had been doing its work diligently, it would have solved the load shedding crisis before I arrived at Eskom. I was relieved when President Zuma closed it down in favor of giving management a fair chance at fighting load shedding and turning the economy around, and turning the company around. Under my leadership, and the leadership of and the leadership and technical expertise of people like Mr. Koko and other engineers, the engineers at Eskom, the guardians as they call them, the employees of Eskom, who, when I was there, became very invigorated and determined to end load shedding. We defeated load shedding in August 2015. On the 8th of August 2015, we stopped load shedding. And we never had load shedding again for 3 years after I had left Eskom. Load shedding came back to Eskom after Mr. Cyril Ramaphosa following the 1 billion rand Nasrec conference, was appointed president of the country. That's when load shedding came back. And after he was appointed president of the country, and he in turn appointed the smooth-talking and dictatorial Pravin Gordhan as Minister of Public Enterprises. The less I say about Pravin Gordhan, the better. As you see, Chairperson, despite his smooth talking, public enterprises are failing, and it appears that they are on a course to be sold to private interests. My suspicion is that, like the javelin, they will be thrown over the fence and be caught at the later stage. It's just a suspicion. To put it mildly, Chairperson, the situation made me sick. I found the behavior of Glencore and that of Mr. Cyril Ramaphosa to be revolting. Mr. Ramaphosa must have known about what Glencore sought to achieve. He was the chairperson of the company that was bought without a due diligence. He was chairperson when the penalties were imposed. He was still chairperson of Optimum when the unlawful agreement that sought to increase the price of coal from 150 and set aside the penalties was negotiated with certain members of Eskom staff in 2014. He knew that he was being used for his political standing and hoped to influence matters to Glencore's favor. He had an interest in the matter, 9.64% interest. He is not naive, and he has been dealing with these corporates which gave him his riches. Mr. Machela Gogo, who I interrogated at length about this agreement that was entered into before I arrived, told me that the board had not sanctioned that agreement. He also told me that the official who had signed it had no authority to do so. But this is hearsay evidence, which I shall not burden you with. Although it is hearsay evidence, Chairperson, at least I know it was Mr. Koko. I'm not telling you it was somebody's brother that I don't know. I hope that Mr. Koko will shed more light on this aspect when the Commission ends its fascination with the suspensions of the executives in the hearing of his evidence. Dr. Ben Gubani and members of his board understood the situation perfectly well. For them, I received the blessing to do what was right. And for that, I'm thankful. It is a pity that this Commission on State Capture missed an opportunity to investigate the nature of the cost-plus mines and 40-year contracts and what is currently collapsing Eskom. It is truly an injustice to the entire economy. If this were to be investigated properly, we will all see the real problems from which we are being diverted. I believe, with the blessing of Mr. Cyril Ramaphosa and Pravin Gordhan. I find it to be strange that the focus is on Tegeta, given the fact that the Tegeta supplied less than 4% of Eskom coal, while in 2015, 4 other white-rich companies supplied more than 80% of Eskom coal to the value in excess of 40 billion rand per annum with 40-year contracts. It goes into the trillions, Chairperson, over the 40-year period. And yet, we're here talking about this meeting, that meeting, concerning a company that was quite literally not supplying much. While some of us did not have the privilege of explaining our side of the story in an interview with the former public protector with respect to Optimum Coal mine, It is clear that Glencore had unfettered access to her and were able to impress on her what their beef with Eskom was. Mr. Efron testified in this commission on page 7 of the transcript during his hearing on the 27th of February 2019. He testified that they did have a meeting with the Office of the Public Protector, something that I was not afforded as a person against whom they were complaining. She did not bother to interview me for my side of the story, as is required by the Public Protector Act. Section 7(9) talks about what the Public Protector must do when a person is implicated. She must inform the person and give the person an opportunity to be heard and to interview the witnesses that came with the evidence. She did none of that. Instead, she proceeded in unprecedented haste to write and label as final a report which has been used by the media to lynch certain people, including myself, and which gave rise to this commission. This commission is the child of a report that was written in very suspicious circumstances. That is when Ms. Madonsela was leaving and was in a hurry, as if there was not going to be a public protector anymore in South Africa. Glencore is a multi-billion rand company. Their BE partner, Mr. Ramaphosa, subsequently rose to become the deputy president and then president of the country. It is rumored that, and this happened without any cooling off period, it is rumored that his campaign to become president of the ANC was financed to the tune of 1 billion rand. This was unprecedented in the African National Congress. I dare say that it was not in line with the culture, values, and ethos of the ANC that I had come to know and which I continue to be a member of. Mere mortals like myself simply do not stand a chance when we pit ourselves against these powerful forces who are trying to extort 8 billion rand from a state-owned entity, Eskom. Constitutional bodies wrote powerful reports about us, and no one dared to question their procedural fairness, their disrespect for natural justice and the Constitution, because the right to be heard, I believe, is in the Constitution, or even the unlawfulness in the manner in which the Public Protector's Office under Thuli Madonsela had conducted itself by disregarding Section 7(9) of the Act. Nevertheless, I continue to have faith in our Constitution, the principle of transformative constitutionalism and the rule of law. I'm aware, Chairperson, that even as I make this statement, law enforcement agencies may be ready to pounce and charge me with criminal acts. I appear before you and state that my conscience is clear. This I know because the spokesperson of the SIU, Mr. Khanyago, said during a television interview about the pending civil case relating to Eskom against myself and others, that they had not concluded their investigations, that they had not interviewed me, and that the civil court process against myself and others is part of their investigations on myself. The abuse of law enforcement and constitutional bodies is not a myth. But no amount of manipulation of state institutions and agencies and intimidation will deter me. It is unfortunate that the courts appear to have also fallen to the narrative of the so-called state capture, which, by the way, Chairperson, you must still establish whether or not it existed. This was the purpose of this commission. But people talk as if you already made your findings. Sometimes even your own tongue slips and talks about it as if there is a finding. When this nightmare is over, our country will return to normalcy. I hope that after this nightmare, some amongst us will desist from political lynching and purges and rather focus on the sacred task of rebuilding our country. I will assist the Commission as best as I can. Just for the record, Chairperson, I submitted this affidavit that is in front of you in May. I have written numerous letters to the Commission requesting to come. And I was told that I'm not scheduled and I must wait and so on until December. And in December, to my surprise, what I get is a summons. A summons to a person who's been begging to come. I felt the Commission has a right to issue summons, but I felt like it was unnecessarily hostile. Because all it took, even if I had been sent an SMS message, Chairperson, I would have been here. After the summons was issued, the first thing that we did is, we received your summons, we're happy to come, please indicate what it is about. Which matter? Is it Transnet, Eskom? Is it Eskom? Which Eskom matters? No reply. No reply, right through December, no response. Until 3 days before the day on which I was supposed to come. Tuesday night at 10 o'clock at night, we received the documents. 1,400 pages of documents. I've spent the last 2 days going through the documents. I did not sleep last night because I did not want to come here and say to you, Chairperson, can we have a postponement? I wanted to engage. After all, I had said that I had been ready for a very long time. But it is unfortunate in the manner in which this was done. It is also unfortunate that it may portray me, for lack of not going through some of the parts of the documents, as a person who is not prepared or who is reluctant to appear before the Commission. Despite the fact that I was advised, legal advice was, you must treat this carefully, this is very serious, you can't go in without having gone through the documents properly. I insisted that I will appear. That is why, Chairperson, I've been seeking to come and present my side of the story. A natural justice right that was denied to me by the former public protector. My heart is at ease. I'm ready to face the consequences of following the dictates of my conscience. Thank you, Chairperson.
Thank you, Mr. Molefe. I think there are certain parts of your statement which make me wish we had received it in advance.